for Health Insurance Portability and Accountability Act. It's a governing body, if you will, under ERISA, another acronym, which is the Employee Retirement Information Security Act, that sets standards for retirement plans and health plans in terms of disclosures to participants, and making sure that the plans are run in the best interest of the employees, the participants that the benefits are being provided for. So today we're focusing on the HIPAA privacy rule. HIPAA has other regulations in it. It addresses things like pre-existing conditions, the ability for people to have portability with health insurance. But again, our focus today is going to be on the privacy rule, and in particular, protected health information. We're fortunate to have with us today Elizabeth Small from our General Counsel office, and we have an attorney, Andy Siegel from Saul Ewing, joining us today to help with this training and presentation. So again, I'm going to remind all of you to please hold your questions till the end, if you wouldn't mind. And I'm going to go ahead and turn things over to Andy.
Thank you, and thanks to all of you for having me. It's great to be here. I was telling Christine, I do several of these trainings a year, and this is by far the best timing. Right before lunch, everyone's still alert. The last one I did of these was at 4 o'clock on a Friday afternoon, so not much attention being paid then. So let's, sorry, you said this is, yeah. Objectives for today. We're going to talk about HIPAA in general. As Christine mentioned, HIPAA has several different parts. The focus of today will be the privacy rule. We're going to talk about what sort of information is protected under the privacy rule. We're going to talk specifically how this impacts Johnson & Wales, your policies, how that governs and controls the protection and use of this information. We're going to talk specifically the pieces of HIPAA that will affect how you use and disclose the protected information. We're going to get briefly into state privacy laws. HIPAA is a federal law. There are also state privacy laws that will interact and conflict sometimes with HIPAA. And then we're going to tie it all back in with the presentation you just heard from Nick on the security rule, how the two pieces work together in HIPAA. So this is the scaring slide. Just to get your attention, I'd just like to start off with stressing the importance of complying with HIPAA. What's at risk if you're not compliant, if you have a violation of HIPAA? There are steep civil monetary penalties and sometimes criminal penalties. One of the effects of Obamacare, the Affordable Care Act, ramped up some of these penalties. So now they are anywhere from $100 per violation up to $25,000 per violation. This depends on what the knowledge elements are, if the disclosure, if the violation is made knowingly, if it's inadvertent, if it's sort of a deliberate act or indeliberate. All of these sort of range in penalties. But more importantly, institutional reputation. A lot of these breaches make the media, and you'll hear about a violation, a disclosure of beneficiaries' information, and it's harming to the institution, the entity. HIPAA is enforced by HHS, Department of Health and Human Services, the OIG wing. It's the Office of Civil Rights, the Investigator General. One thing that's important to note is that HIPAA does not, it's known as it does not create a private right of action. In other words, if John Smith's information is disclosed in violation of HIPAA, John Smith cannot sue Johnson & Wales. How he has recourse is he files complaints with HHS, they launch an investigation, fines are handed down that way, but there's no private right of action. Just an interesting wrinkle. But just a few examples of HIPAA violations that have been in the news recently, a few local examples. Last month, there was a healthcare provider in Boston, Massachusetts Eye and Ear. Some laptops were stolen. The laptops contained beneficiaries' information. Investigation, there was a breach notification, investigation was started. They found that Mass Eye and Ear had no HIPAA policies in place. They didn't do training. They didn't have notice of privacy practices. None of these sort of institutional safeguards that are required. They were fined $1.5 million for a small provider in Boston. Several years ago in Warwick, down the road, Kent Center is a substance abuse center. They also had a theft of a laptop. They were able to catch in time. They notified anyone who was affected. No fines, but it still made the media. These are the things you try to avoid. And then 2 years ago, Blue Cross Blue Shield Rhode Island were moving their offices apparently and donated some equipment, file folders, cabinets, desks, things like that to a charity. Several months later, someone at the charity opened up one of the desk drawers, and there were files in there containing 35,000 Medicare surveys from beneficiaries containing Social Security numbers, medical records, forms like that. Not a good idea. Blue Cross Blue Shields avoided monetary penalties, but they had to overhaul their compliance system. They had to notify the individuals. I believe they did credit reporting to check to see if anyone was affected by this. Just, you don't want to take the institutional hit. So that's the scare slide to start you off with. So what is HIPAA? Christine mentioned that HIPAA covers a few things. It started out as insurance reform. It's the Health Insurance Portability and Protected Act. And as she mentioned, this is what allows you to change jobs while keeping coverage. This is also where the first instance of pre-existing conditions came into play. This is also, HIPAA was enacted in 1996. This is the first time where CMS and HHS started to go after Medicare fraud and abuse. What it's come to be known for now is the administrative simplification. It created a framework for the standardization of exchange of information. In 1996, they had the foresight to see that a lot of health information was being exchanged electronically. Back in those days, it was fax machines and emails. Now it's scanned copies and PDFs and handhelds. But that's the framework was formed then. The administrative simplification aspect of HIPAA has several parts. The electronic transactions and code set standards, that established the standards of CPT codes, ICD-9, whenever your provider is sending a claim to a biller. That sets up the CPT codes that they use. The final bullet point here, identifier standards, creates the NPI, the National Provider Identifier. Every healthcare provider has a number they use for their billing. The fourth bullet, the electronic signature standard, not much came of this actually. Congress eventually passed a separate bill that allows people to sign for things electronically. When you see the I hereby accept and you click the button, that's that. But the two big bullet points, the privacy standards and the security standards. Nick's already talked to you about the security standards. We're here to talk about the privacy standards. And what is protected? We're going to sort of build up a definition here. We're going to talk about the information that is covered by the privacy rule under HIPAA. So we start with health information. And health information is any information that is created or received by a provider, a plan, public health authority, an employer, an insurer, a school, university, a clearinghouse. This is in any medium, any format, oral, written, electronic, that relates to the past, present, or future physical, mental health condition, or the provision of health care services, any treatment of any individual received, or any past, present, or future payments for such care. So that's the health information definition. HIPAA covers individually identifiable health information. And this is health information that either identifies an individual on its face or contains enough information that it's reasonably believable that you will know who that person is. We'll see in a little bit, there's 18 characteristics which helps identify an individual. HIPAA focuses on the protected health information. This is individually identifiable health information that's transmitted or maintained in electronic or other form or medium. Now, this does not include information that is contained in educational records. There's some interplay between HIPAA and FERPA, which is the Family Education Rights and Privacy Act. If it's and FERPA is a different set of regulations. It's governed by the Department of Education, not Department of Health and Human Services. The violations are different. The uses of educational records are very different than the uses of medical records under HIPAA. The violations, as I understand, are a lot less stringent, but you need to be aware of the differences. Educational records, if it's something that directly relates to a student, another piece of FERPA is a treatment record, which is a medical record made specifically for that student, and the only person that sees it is their healthcare provider. Educational records and treatment records are not covered under HIPAA. They are governed under FERPA. So it's an important distinction. But HIPAA covers PHI. For our purposes here, this is the protected health information of the plan beneficiaries. Anything on one end of the spectrum, you have protected health information. You can have information that has been de-identified, and this is, in other words, unprotected. We mentioned the individual identifiable. These are the identifiers. There are 18 of them. If it contains someone's health information and their name, their address, the date that they received the medical service, their date of birth, you can see telephone, fax numbers. If the information that is being used or disclosed does not contain any of these information, and you'll notice the final bullet point is any other unique identifying number. If it doesn't contain, if it's been scrubbed of all of these identifiers, then it can be used for any use or purpose. But if not, then it's protected. It's protected health information, and we'll talk about the proper uses and disclosures. About once a year, we probably get a call about a nurse in a hospital. We represent a lot of healthcare providers. We have a lot of cases of nurses posting things on Facebook. Look at this, and they post a picture of their patient, or post a picture of some interesting case. And this is where it gets into problems, because within that picture on Facebook, there's enough identifiers. If you can tell who that person is, you've got a HIPAA violation. So those are the identifiers. So we talked about what information is covered. Let's talk about who it affects. The privacy rule affects 3 different groups. We call them covered entities. And I'll start from the bottom one first. Healthcare providers are the hospitals, the physicians, the dentists, anyone that furnishes healthcare services. And not only that, anyone who transmits any information in connection with the provision of services. In other words, they have to bill for it, they have to submit claims electronically. Another reason why sometimes you have colleges and universities have health clinics on sites, not only are the student health records not covered under HIPAA, they're covered under FERPA, but the health clinics usually don't bill. They'll see the students, they'll treat them, they'll release them. They'll keep the records, again, protected under FERPA, but under HIPAA, because the provider is not submitting claims electronically, they are not a covered entity. The second category is clearinghouses. These are billing companies. These are companies that take unformatted information and format it, not applicable. The first bullet point here are health plans, and these are individual and group plans, provider pay for. This is health, dental, vision. This includes HMOs. This includes Medicare and Medicaid payers. A couple exceptions: if it's a self-funded plan with less than 50 participants, or if they only cover workers' comp or auto insurance. But brings us to Johnson & Wales. This is why we're here. Johnson & Wales has an employer-sponsored group health plan, including dental. This falls under the covered entity definition of the privacy rule. An interesting nuance, it's actually the plan is the covered entity. You as employees at the university are operating on the plan's behalf, also part of the covered entity. But so, to recap so far, we've covered what information is covered, the protected health information of the beneficiaries. We've talked about who it pertains to. It's covered entities, it's plans, providers, healthcare clearinghouses. The privacy rule itself regulates the use and disclosure of the PHI, of the protected health information, by the covered entities. And it creates standards for the individuals. They have privacy rights on how the information is used and disclosed, how each of you can use and disclose their information. We'll get to that shortly. First, let's talk about the Johnson & Wales policies. I think if we want to sort of get into a little more detail about not just the WISP, but some of the other policies where.
Thank you, Andy. I think really for this particular slide, the point that I'd like to make is, again, to call your awareness to the fact that we do have the HIPAA privacy policy, which you've all been asked to read and review, as well as the WISP policy and the training that we had earlier on the WISP. You know, it's important that we be aware of them, that we understand them, and that we understand the safeguards that we need to take in order to protect the information that we come into contact with. What I would like to provide are some examples of protected health information, specific information that we come in contact with in our department. The enrollment information, the health and dental insurance enrollment information that is provided when employees fill out applications, the Blue Cross Blue Shield applications and the Delta Dental applications. That information is considered protected health information. The information that is in our HRIS system in payroll for purposes of entering the employee's election as to the insurance that they have elected, the level of dental coverage, and then the dependents that they are able to enroll in those plans. That information is protected health information. So those two elements are elements that often all of us as members of the department come into contact with. There are also additional data that the benefits staff works closely with. We get invoices from Blue Cross Blue Shield of Rhode Island and Delta Dental of Rhode Island. That information is considered protected health information as well. The campus HR managers in their roles of enrolling employees on the health and dental insurance plans come into contact, obviously, with the enrollment applications. So I just wanted to speak briefly to a couple of examples as to how this directly affects us in our day-to-day activities in the office.
Examples. The privacy role has a number of administrative requirements. First of all, each covered entity has to appoint a privacy official, an officer, a contact person for complaints of violations. You have Christine here as your privacy officer, right there. Sorry, let's go back. Training, mandatory. You're here, you're fulfilling that requirement, but it is required under HIPAA that all employees that have access to or contact with protected health information undergo training. So that part has been accomplished today. Every covered entity has to have safeguards in place. Nick talked about, I believe, some of the IT safeguards in place for protecting the health information. Every covered entity has to have a format for filing complaints. Yours is Christine, and we'll talk about that, how either an employee or an individual becomes aware of a violation or a breach and would want to file a complaint. Employee sanctions is another piece of the administrative requirements. Employees that are found guilty of violating HIPAA, again, it depends if it's a knowing violation or an inadvertent violation, but there are sanctions in place for employees that covered entities have to follow. Every covered entity has to mitigate any breaches. So if they become aware of a violation of HIPAA, they have to do everything in their power to minimize the damage. Intimidating or retaliatory acts. No beneficiary under a plan can be subject to a retaliatory act for filing a complaint, for making a request for further information. We'll talk about some of the individual rights that each beneficiary has, access to their PHI. They can't be discriminated against or retaliated against for exercising their rights. They can't be asked to waive their rights also. Another administrative requirement is no waiver of rights. Every covered entity has to have policies and procedures in place. Johnson & Wales does. And then finally, we'll talk about this later, every covered entity has to have documentation policies for preserving and maintaining documents, different HIPAA requests, the policies, things like that. It's 6 years is the limit, but we'll get to that. So under the HIPAA privacy policy, Christine is the privacy officer, the privacy compliance team, and if you have anything to add to this, but all the employees who perform administrative functions on behalf of the plan, apparently everyone here is a member of the privacy compliance team. So everyone has access to PHI in this room. Everyone is subject to the privacy rule under HIPAA. How do we use and disclose protected health information under HIPAA? The PHI, Christine mentioned, the enrollment forms, the beneficiary information that's come across your desk every day. There are 3 ways we can use and disclose PHI. There are permitted uses and disclosures, there's mandatory uses and disclosures, and there's authorized uses and disclosures. The permitted uses and disclosures are the 3 big ones. It's TPO is the acronym. Permitted to disclose and use PHI for the purposes of treatment is the T, for purposes of payment and healthcare operations. Treatment is, I think, pretty self-explanatory. Providers can use for provision of care, for consultations, for referrals. Disclosures for payment purposes. This is your billing, this is filing claims, this is reimbursement, this is data processing. And then finally, healthcare operations is the administration of the plan. Your internal, if you're filing reports, if you're reviewing past performance of the plan, things like that fall into the operations bucket. If the disclosure is not recurring, if it's a sort of a one-off or unusual request, see Christine, see your privacy officer. If it's your day-to-day filing reports, submitting claims, processing enrollment, that again falls under treatment payment operations and is permitted without assigned authorization from the beneficiary. A few other permitted use and disclosures. Again, these are the uses and disclosures that do not require authorization. Any disclosures to the individual. If you're sending anyone a mailing containing their information, you don't need their approval. Incidental use and disclosure. It's kind of a funny line, and I hate that it's part of HIPAA because everyone always asks what's incidental. The example I like to give is you're faxing a report or a fax to someone that contains private information. You leave the fax on the fax machine. Your colleague walks by and picks it up and looks at it and says, "Oh, you left this on the fax." Incidental. You don't want to ask you don't want to go too far beyond that because then you start to get into a breach. But you like to say you know it when you see it. Uses and disclosures with the opportunity to agree or object. There are certain non-formal and informal uses and disclosures. Anytime then you have a prescription at the pharmacy and your husband or wife goes and picks it up, they're accessing your personal health information, but the pharmacist considers them to have authorization to pick it up. Limited data sets. The plan may use and disclose information pursuant to a limited data set, which is it's a form of data use that the plan may compile information and send it to a third-party vendor for research, for analysis. This is subject to a data use agreement between the university and whoever the vendor is, so there is some confidentiality protections in place with limited data sets. Finally, there are a whole host of examples under HIPAA for public interest and benefit activities. A few of them are you may disclose to law enforcement officials for law enforcement purposes, pursuant to a court order or a subpoena. Sometimes you'll get a subpoena in the matter of a divorce proceeding and they'll want to release the wife or the husband's medical records. If you're acting in accordance to a subpoena, that's permitted without authorization. And again, I can't stress it enough. If you have any questions about a request, see your privacy officer, see Christine. A few other public interest benefit activities. If there is an imminent threat of risk or bodily harm, if there's some damage that's going to come, you can alert law enforcement officials without violating HIPAA, sort of a carve-out to protect that. Two types of required use. The first is if the individual specifically requests access to or an accounting of the disclosures made of their protected health information, you must disclose to them. This does not include, there's an exception for psychotherapy notes, or if the information is compiled by JW in anticipation of a legal proceeding, you don't have to share that with the individual that's making the request. The second is to Health and Human Services. If they're undergoing an investigation, then you must disclose any protected health information that they ask for, again, without authorization of the individual. Everything else is forbidden, is prevented from using and disclosing unless you have the written authorization from the individual. Aside from using it for payment, treatment, healthcare operations, some of the public policy exceptions, everything else needs a signed authorization. Contact Christine to determine whether we have one on file from the individual making the request. All use and disclosures made pursuant to an authorization. The authorization will contain the terms. They'll contain a description of what information is being disclosed. They will contain the name of the recipient, who's receiving it, who's going to be, what they're going to be using it for. It has to be a very detailed authorization. It must be dated. It can't be expired. It can't be 10 years after the individual signed the authorization. All uses and disclosures, whether they are the permitted uses and disclosures, the payment, the treatment, the operations, whether it's a required use and disclosure, whether it's an authorized use and disclosure. Every use and disclosure has to be subject to the minimum necessary standard. What this is you must make reasonable efforts to minimize the amount of PHI needed to accomplish the purpose of the use or disclosure. Like to ask yourself two questions. You say first, is this disclosure necessary? Is it the minimum? An example of this would be a billing company contacts you and says, has Mrs. Smith, we're calling to confirm that Mrs. Smith had her procedure last week. What was the date of procedure? You can provide that information that is pursuant to payment or treatment. That's a permitted disclosure. What you can't do is you can't tell them the results of the treatment. You can't say that it was a negative result. You can't say any other information beyond what they were asking for. Minimum necessary. You keep the disclosures to the minimum, absolute minimum necessary to perform the task. Of course, everything has exceptions. If it's a pursuant to valid authorization, we have the authorization form on file, then you may disclose to the extent that the authorization permits it. So you don't have to go through the sort of the analysis of what's the minimum disclosure that's required here. Whatever the authorization allows you to, that's what you can disclose. Any disclosures to a provider for treatment, we want the beneficiary's doctors to have the full file, the full information, not subject to the minimum necessary standard. If it's to the individual, again, you don't have to conform to the minimum necessary standard. Disclosures to HHS for investigations, these required disclosures, not subject if it's required by law. And then there are several other exceptions within the administrative simplifications rule, which I have yet to see come into play, but just aware that there are other exceptions for when you have to use the minimum necessary standard. Keeping good documentation is absolutely crucial. Whenever a disclosure is made, you want to document the date of disclosure, who received the PHI, the address would be great, brief description of the protected health information that was disclosed, statement of why, the purpose of the disclosure, why it was used, other things that must be documented and retained, JW's notice of privacy practices that go to all plan beneficiaries, any authorization forms that we have on file, any beneficiary requests for information, they can request to amend their PHI, they can request an accounting, any request, any communications with a plan beneficiary you want to keep on file. HIPAA requires to be on file for 6 years from the day the documents were either created or last in effect. If any policy has been modified, then 6 years from the date of modification. You will receive requests from beneficiaries' spouses and their parents and their family members and their friends. What do you do when you get a call from Mrs. Smith's husband and say, can you let me know this piece of information, or is my son enrolled in this? Generally, the individual who's the subject of the PHI must be informed. They must be given the opportunity to agree or to restrict. If it's from the parent of a minor child, I'm not sure that would come into play with the beneficiaries of the university's plan, but we'll talk about how to verify an individual's identity. An individual is permitted to restrict to whom the information is provided. They can call you up and say, I don't want you sending my information to these people. We must agree to that, and that must go on file, must be documented. But you will receive requests from someone who's not the subject of the PHI, and you have to verify their identity. This can be either a government ID, if you're over the phone, a social security number. If it's a parent of a child, you want to verify the relationship. If someone is calling on behalf of an estate or a personal representative, you would like to request a copy of their power of attorney that allows them to access a person's personal protected health information. If you're contacted by HHS, local law enforcement, request to keep a copy of the credentials. Obviously ask questions before you start sending information out. Verify everything on letterhead. Again, keep copies of everything for the 6 years requirement, but maintain good copies of all documents. And obviously, if any requests come in for subpoenas or court orders, see Christine, but I would even say see Christine for any other sort of requests out of the ordinary. Additional safeguards. You're using a disclosing PHI in accordance with the privacy rule, but you have to keep additional safeguards. Nick covered last hour a number of different IT safeguards for computers. It's really common sense things. PHI must be kept locked away. Don't keep it on your desk. It must be stored in a secure network. Johnson & Wales, all covered entities are not allowed to sell PHI for compensation, so that the bullet on no direct remuneration exchange for PHI or marketing communications. Do you want to talk about fundraising issues briefly? It rarely comes into play. The privacy rule has requirements if you're going to use PHI for fundraising or marketing purposes, but again, it's very rarely used. A couple other safeguards, again, common sense. You're sending out faxes, keep track of the faxes, keep track of the documents. If you have shredders, use them. You don't want these documents to float around. A large number of HIPAA violations come in from lost USB drives, lost laptops, files that are left taken out of the office and lost. These are all violations, these are all breaches, they're all reported. They all have civil or criminal penalties involved, but it's simple things. It's just keeping track of the information. Leaving voicemails is another often a violation. You call up someone to respond to a request, and you say, I'm calling about this, and you say the protected information. You give a piece of information over the voicemail, you leave it on the answering machine. That's a violation. Try to keep it to, I'm calling on behalf of JW, please call me back, and leave the information out of the message. All plan beneficiaries have rights to, under the privacy rule. Sorry, they have to receive the notice of privacy practices, and when they enroll in the plan, they will receive the packet. This is one of the documents they will receive. It tells them what their rights are. It tells them what JW has to do with their information, their uses and disclosures. It informs them of their right to access their PHI at any time. They can contact your offices and get a copy of their file. They have a right to amend their PHI if they believe that what's contained in their file is incorrect or incomplete. They have a right to request an accounting. Please send me a list of everywhere you've sent my PHI. If you've sent to any third-party vendors or any outside parties, they can request a list of all disclosures of their information. They have the right to request an alternate communication means. If they don't want you sending their information or mailing to their home address, if they prefer to receive it at work, you have sort of confidential matters sometimes, and some people don't want information being sent to their home address where any member of the family can pick up a medical record, for example. And finally, I mentioned this before, a right to restriction request. If they don't want a certain member of their family or some other individual from accessing their files or requesting PHI, they can request that only they receive and only they are contacted. This comes into play. We get calls excuse me, from clients going through custody battles or a divorce dispute where they don't want their ex-husband or ex-wife getting access to their medical files. So they can request that the covered entity restrict who has access to their files. And finally, the individuals have the right to file a complaint. If they become aware of any breach of their PHI or think that there has been a breach of their PHI, they have a right to complain either directly to HHS, which will launch an investigation, or you will get a phone call and refer it to Christine and follow through in that manner. Employee sanctions required under the privacy rule. Both the WISP and the privacy rule require that all employees comply with requirements. Sanctions will be imposed against any employee. Each covered entity has their own internal policies, but failure to comply you will be subject to sanctions, including termination of employment, depending on how egregious the violation is. Again, these are mandatory and must be imposed by JWU. Covered this earlier, but Johnson & Wales cannot retaliate against any individual, a member of a plan, for exercising their rights, for requesting access to their PHI, for requesting a disclosure of accounting. No employee can intimidate, threaten, coerce, discriminate against anyone for exercising their rights. For filing complaints, for contacting HHS, launching an investigation, they are protected. These are their inalienable rights. Again, covered that no individual could be required to waive any of their rights as a condition of signing up as a condition of enrollment or eligibility in the plan. Who else is covered by the privacy rule? We have the covered entities. These are the providers, the clearinghouses, and the plan. The plan will contract with third-party vendors, your billing companies, your legal counsel, your accountants. There will be other parties where you will need to send information to them so that they can do their job. If I get a call for a legal question that requires my client to send me information about a patient, that is a disclosure of the information to me. I am a business associate, is the term used under the privacy rule, performing certain functions or activities on behalf of the covered entity. A few examples there, claims processing, the legal, accounting, consulting, things like that. The covered entity, JW, must enter into a business associate agreement with any third party to whom PHI is shared. That business associate agreement will cover the confidentiality, will cover liability. The business associate will be liable if they have a breach on their end. They have their own duties and responsibilities under HIPAA. They must notify JW. They must notify the covered entity if there is a breach on their side of things. The Affordable Care Act, Obamacare, has strengthened some of these requirements. So now the business associate and the covered entity are both on the same footing. If there's a violation on one end, the other is equally liable. Before, it was the business associate. If they had a violation, it was on the covered entity. For the covered entity had to keep track of their business associates, but now the business associate is also liable. And I believe that there are business associate agreements on file. Each of the vendors you use, Shredded, Ben Strat, Blue Cross Blue Shield, Dental, some of the vendors that you have contracts with, there is a business associate agreement file that says we will be sharing our beneficiaries' PHI with you. You must keep it confidential, subject to the HIPAA privacy rules. Breaches are violations of the privacy rule. The formal definition under HIPAA is an impermissible use or disclosure that compromises the security or privacy of the PHI, such that the use or disclosure poses a significant risk of financial, reputational, or other harm to the affected individual. There must be an element of harm. The fax copy that's picked up on the fax machine, you could argue that there's no damage to the individual because it's one of your colleagues looking at it. You don't want to go down this road. This is a violation. HIPAA requires, depending on the severity of the breach, how many beneficiaries are involved and affected. There are different levels of reporting. If it's over 500 individuals, you must notify HHS. If it's a larger breach than that, you actually have to notify the media so that they can post either a news report or a newspaper article to notify. When Blue Cross Blue Shield of Rhode Island had the incident where thousands of beneficiaries' information was sent off to a third party in a desk drawer, they had to, I believe they printed it in the newspaper, notifying if you are subject, if you've been affected by this, contact us. You have to notify the people. So different levels of breaches have different ramifications and responsibilities. What should you do if you're concerned that a breach has occurred? Well, first, report it to your privacy officer. The ISM is
Actually,
yeah, absolutely. Come on up, please.
The methodology that we've created is to call safety and security first. Why? Because they're available 24/7, and every once in a while somebody's laptop gets stolen and safety and security actually goes and chases them down with the police, and once or twice they've managed to get the equipment back. So if it's a physical stealing, something like that, safety and security will be able to address it right away. If it's something that's electronic, what safety and security is going to do is they're going to call NIC right away or the help desk and get on that right away. With respect to possible PHI breaches, that's also going to go to Christine, so she's looking at that as well. You know, the bit about there has to be some harm, the analysis can get pretty darn complicated about whether there's been a breach or not a breach. We're going to leave that to the ISM and the privacy officer and the general counsel's office to figure that out. So as Nick said, if you even suspect or have a glimmer of an issue, it would be better to call and discuss it. And as Andy said, We also have to consider our business associates as well. So it does get quite complicated, and good communication will help, and you guys have been great so far on that. The HIPAA privacy rule is actually the floor. It's kind of scary to think, but we have employees in every state. It's possible that a state law is going to provide greater rights. The lucky thing is we really don't have really incredibly sensitive information coming under the plan. So it's unlikely in the course of benefit administration you're going to find out about a gunshot or child abuse or elder abuse or an Ebola outbreak or something like that. But if you do, definitely call the general counsel's office and we can investigate it. Because we would have to look at the specific state law. We haven't run into any issues in the 5 states we're in, but you never know, it could be somebody out in Iowa or something like that. To you.
And if you hear about an Ebola outbreak, can you call me too, please? In addition to Christine. Yeah. So, for example, of the states, the federal floor. I practice in Pennsylvania. And Pennsylvania has very strict rules on what can be done with drug and alcohol records. So those would be not only subject to the HIPAA privacy rule, but if you're disclosing drug and alcohol records, there's a lot more stringent requirements on when you can and can't use it. So additional security on top of HIPAA.
The HIPAA security rules are actually pretty darn similar to other requirements. If you're told to lock your door under Gramm-Leach-Bliley and you're told to lock your door under HIPAA, why have 2 separate requirements to lock your door? So what we did for the WISP, we kind of gathered up all the security requirements and put them in the WISP because there are quite a few laws that really overlap. And then we also have the privacy policies separate. Nick is always available. He's a wonderful resource. And if you have any questions, definitely call him and he'll get right back to you.
Sorry, let me just to recap sort of how the privacy and the security rules fit in. The privacy rule covers, it lays the foundation for the HIPAA privacy. It tells you what information is protected. It's your protected health information. We talked about it's information that you have the identifiers. If it's not de-identified, then it's protected. We talked about what entities are covered, what are governed by the privacy rule. You have your healthcare plans, providers, clearinghouses. And we talked about the uses and disclosures, both permitted, required, and authorized under the privacy rule. When you build in the security rule really tells you the hows. It's how we keep this information safe, whether electronically, whether on our information systems, whether physically in the offices. The 2 work side by side like that. Do we have time? Yeah.
Okay, very good. Thank you very much, Andy. Thank you, Elizabeth. I want to open it up to questions. Does anyone have any questions for anyone? Danielle?
I just had a question on slide 18. It made mention of personal representative. And I wasn't sure what the definition, if there's a definition of what a personal representative is, or how we would know.
Sure. That gets into if you're contacted by, and it's slide. Request from spouses, slide 24. A personal representative could be the parent. It could be a legal representative, a legal guardian, if they have a power of attorney, if they're calling on behalf of an estate. There's different levels of what a personal representative could be. That's sort of the catch-all. Anyone who's not the individual is contacting you.
So how would you verify that over the phone if you receive a call?
So the question is, how would you verify who the personal representative is over the phone?
Right. You would typically have, when the individual signed up, they would have representatives on their form that you could contact that would be able to receive information. If not, you'd want to contact the individual directly and get their approval first. If it's an emergency situation, you can request Yeah, identity verification. You can request a copy of their identification, social security number, something else that can verify with the information you have on file. The person's mother is calling, if you can do your best. Again, an emergency situation, I would ask you to call Christine to work through it, but ordinarily, you would contact the individual to get their approval. This person contacted us, maybe send their protected health information to them.
Does that get trickier when you're dealing with students?
It does, but again, the student records,
Requesting maybe from the student?
again, sure, yeah, the student record is not under HIPAA, that's sort of a difference, and FERPA has its own language on when information can be sent to a parent. If a student would be a plan beneficiary, if they be...
You know, at the present time, we don't have, we have no student
Okay,
PHI.
okay.
So, you know, that wouldn't be an issue.
But hypothetically, if the student were to call, then you would contact their guardian if they were a minor.
And the other thing that I would add in terms of requests that we may get from folks other than the employee, I think we all already have a practice in place whereby we don't disclose information about employees. You know, if someone calls and says, I'm so-and-so's spouse and I'd like to know who's enrolled in the plan, and we do that, you know, throughout the area. We do we do have the policy in place where we explain to people that we cannot provide information to anyone other than the employee.
Absolutely.
So I think that goes a long way to help us in that regard.
Absolutely.
Any other questions? No other questions? Okay, well, thank you all again. The last thing that I am going to ask you to do, along with the printouts of the presentations, there are 2 acknowledgement forms, one acknowledging your attendance at the WISP training, one for the HIPAA training, and then there's a confidentiality agreement. And I would ask that you please complete each of those for us. Thank you again.